Hi, everyone. This is Sam Silverman, Managing Partner of EB-5AN. Thank you for joining on today's webinar. Today, we're going to be discussing EB-5 adjustments of status, and also we'll spend some time speaking about recent EB-5 visa demand trends and how investors are selecting urban and rural projects over the last 2 years. This is a quick overview of what we're going to cover, a little bit about EB-5AN. We'll introduce our guest panelist. We'll talk about adjusting status with an EB-5 investment. We'll talk about recent EB-5 visa demand trends, and then we'll spend a few minutes on some of our current EB-5 projects. So a little bit about EB-5AN. We're a leading EB-5 investment fund manager. We've worked with thousands of families from around the world. We have more than 10 USCIS approved EB-5 regional centers covering most of the country. One of the things that makes us unique in the EB-5 space is a commitment to 100% investment transparency. So we work diligently with developers to make sure investors have access to the complete set of financial information about the projects. We also have a very active blog and YouTube channel with hundreds of posts and videos available for informational details on the process and how to select a project. As I mentioned earlier, I'm Sam Silverman, one of the two managing partners. A little bit more about my background and bio is here on the left-hand side. And this is a quick map showing the regional center coverage area that we have, which allows us to select the most compelling EB-5 projects around the country. And another map showing where many of our prior investors have come from. Most importantly here is that people of many nationalities and backgrounds have consistently found value in our investment approach to EB-5. And many of our projects and articles have been featured in some of the leading publications as well. And now it's my pleasure to introduce Marjan, who's with us today. Who's a very experienced EB-5 immigration attorney who's been in the EB-5 space for quite some time. And she focuses on Middle Eastern EB-5 investors, and I'll let her take over and share a bit about herself and her experience in the EB-5 space, and then we'll jump into the main topic for today on adjusting status.
Hi, everyone. My name is Marjan Kasra. So I'm the managing attorney at LawMax, and thank you, Sam, for having me today. It's a pleasure to be here with you today. So I do manage the EB-5 division at our law firm, LawMax, and my own specialty has to do with investment visas. So I do a lot of EB-5s, L1s, and E2s. We do have offices in Stamford, Connecticut, in New York, in Dubai, and also in Istanbul. So as Sam mentioned, I do specialize in the Middle Eastern clientele, especially because of our office in Dubai. However, recently, Sam, we've been getting a lot of interest from local applicants from India and China, particularly those on H-1Bs and F-1s. And we're happy to represent a whole slew of nationalities in our law firm.
All right, perfect. All right, so let's jump into the main topic for today, adjusting status. So Marjan, can you kind of walk us through what is an adjustment of status and how does an EB-5 investment, confer this ability to an investor, and what are the advantages and kind of who does it apply to and how does it work?
Sure. So adjusting status works for individuals who are here on any type of a non-immigrant visa. So particularly most of the people who are here on a longer term non-immigrant visa, such as an H-1B or an F-1, or even people who are here on a tourist visa, and we can talk about some restrictions with respect to tourist visa applicants, but essentially adjustment of status means changing your status from a non-immigrant visa to an immigrant visa, which is essentially your green card. So with that, you have to file a few applications to change your status to an immigrant visa. Prior to Reform Integrity Act of 2022, people who were filing for EB-5 did not have the ability to file for adjustment of status. But one of the great things that has come out with the RIA is that it does allow you for concurrent filing for your adjustment of status based on your I-526E or I-526 application. So what that means is that we can file the main form for adjustment of status is called I-485. And that form is the basis for your actual green card based on your I-526E or I-526 application. Along with I-485, we file for your work permit, which is done through application I-765. And in addition to that, something that is very important to most of my immigrant application clientele is filing of the I-131, which allows you to come and go as you please while waiting for your actual green card to come through. So what happens is that after we file for your adjustment of status, we wait for about between 2 months to 7 months, depends on how busy USCIS is. But after roughly about 5 to 6 months, we do expect to receive what we call a combo card. And Sam, a combo card is essentially, I call it a mini green card because it essentially allows you to both work and travel while your I-526E is being processed and while we're waiting for your I-485 to process as well.
Got it. All right, let's spend a few minutes and dig a little bit deeper into eligibility. So
Sure.
Who's eligible and who's not, and kind of how does that all work?
Sure. So let's talk about the 90-day rule. So if you're here on a B1, B2 visa, you cannot have the intent to immigrate on the day that you enter. But legally, if you change your mind, let's say your circumstances change, this 90-day rule allows you to change your mind after 90 days of being here and form an immigrant intent after the 90 days. So if you're here on a B1, B2, you certainly cannot file in less than 90 days. But after that 90 days passes, if you're able to show that for XYZ reason my intentions changed, then you can certainly file for your I-526E and followed by your adjustment of status. So that's with the B1, B2 applicants. However, if you're here on a longer term visa, such as an F1 or an H1B, and you've been here for a while, it is quite all right for you to file for your adjustment of status. Especially with H1B and L1 visa holders. So there are only two visas, Sam, that allow dual intent, one being the H1B, the second one being the L1 visa. So if you're here on an H1 or an L1, you don't need to wait the 90 days that I mentioned. If you're here on an F1, though, I do recommend that people wait the 90 days before filing for their adjustment of status. E2 also is not a dual intent visa. It is meant to be a temporary visa that is a non-immigrant visa. So with those visas, you got to be careful and observe the 90-day rule.
Got it. Got it. Okay. Thank you. That's much clearer. Let's talk about just kind of the order of operations and how the concurrent filing and adjustment kind of fit in with the other actions an investor is going to take when they decide to do an EB-5 investment. So let's walk through this chart.
Okay, so essentially, when you first decide, so two things have to happen. You have to pick your project, and there are great projects such as EB-5AN. The second thing you have to decide on is, whether you're going to do a partial investment or full investment. And a lot of great projects such as SAM's, they do generally allow for installment programs where you could invest with smaller amounts and then continue on after that. So once you have those two things set in place, then we file for your I-526E. And to file your I-526E, essentially we require 7 years of tax returns. If you do not have that, we'll just have to explain where your funds came from. So the source of funds is the main thing that we work on with you, and we'll spend a lot of time in identifying the best pool of funds. So you could have millions sitting, but we try to isolate a good source of funds, a total of $800,000 to, and once we've isolated that source of funds that is easily explainable to USCIS, then we'll go ahead with filing for your I-526E. Before that happens, though, you gotta send in your money, which could be again a smaller amount, or it could be the full $800,000. There's always usually like an administrative fee as well, which projects Sam and others at his company can discuss that with you. Once the I-526E is all set, we can also concurrent to that file for your I-485, I-765, and I-131. Now, sometimes some of my clients, they're not sure if they can stick around for the adjustment of status to process. And I always tell them, look, you can either opt for adjustment of status, or just in some circumstances, it just makes sense to undergo consular processing. But if you are able to stay here for at least 5 months or so post filing, then it is safe to file for your adjustment of status concurrent with your I-526E. A lot of my clients are very busy entrepreneurs, very busy businessmen and businesswomen, and they tell me, Marjan, look, I can only stick around for like 2 months after you file for me. And while it is a little bit riskier, what I say to those clients is that, look, we can file for you after we file the adjustment of status and the I-526E. It takes roughly 4 to 6 weeks for us to receive a notice for biometrics. Once those biometrics or fingerprinting is done, then it's typically safe for the client to leave. It's ideal for you to stay here until you have your EAD card, but if you cannot do that, at a minimum, I'd like you to do biometrics before you leave the country. Now, what happens if you leave earlier than that? Unfortunately, your I-485, your whole adjustment of status will be canceled, because if you leave before doing your biometrics, then it's problematic. So I would only advise people who can, in fact, stick around for a bit. Those are the only individuals, Sam, that I would recommend doing the adjustment of status for. So once it's filed, we expect to receive the I-765, which is your work permit. I've received it in as fast as 2 months. So beginning of 2024, we were receiving our I-765 approvals within 2 months. These days, though, it's taking roughly 4 to 6 months. So once we have that I-765 approved, very soon after that, we get the I-131 approvals. Sometimes we get them at the same time. But at the end of the day, you will have both of those things approved, which allow you to both travel and work without any sort of restrictions. And as soon as your I-765 is approved, you will then receive your Social Security card, which allows you to work here without any type of restrictions. Now, even if you're working for an H-1B for a company, you no longer really need to depend on that once you have your I-765. However, Sam, some of my clients do want to keep their options open, so you can have concurrently hold your H-1B status along with your L-1, especially those two are dual intent. So it may be a good idea to keep both options open.
Perfect. Thank you, Marjan.
Sure.
And so let's talk about kind of the bigger picture steps of the initial filing, the adjustment of status component, and then also the petition to remove conditions later.
Sure. Sure. So once everything is filed, I mean, there was a report that came back from IIUSA that indicates people who have filed in rural areas, the average processing time for the I-526E is 7 months. Our law firm has received approvals in as little as 3 months, but those are somewhat rare. The average processing time for the rural regional centers is 7 months. The average processing time for TEA applications is 14 months. So this is data as of July of last year, which was uncovered by time. If you're here, to be quite frank, it almost doesn't matter if you're rural or targeted employment area. Why is that? It's because the I-485 itself takes roughly 19 months to process, right? So whether you are in TEA or rural, some people prefer to have their I-526C approved, and that's great. And in those cases, it's a good idea to go into a rural project. However, if you're here, it almost doesn't matter because by the time your I-485 processes, we anticipate your I-526 to process as well. And unless the I-526E is approved, the I-485 doesn't get approved. However, because the TEA and the I-485 the I-526E based on TEA and the I-485 kind of run on the same timeline, it almost doesn't matter which type of project you go into. So once your I-485 is approved and you have your conditional green card, you have to wait another 24 months to file for your I-829. However, we can actually file 3 months before that 24-month period runs out. So we start talking to our clients about 6 months before the 2-year anniversary, and we're able to file it 3 months prior to the expiration of your temporary green card. So the I-829, Sam, is the stage where we have to prove that the regional center actually created those 10 jobs. So that's
Right.
where the condition on your green card is removed.
Perfect. Let's do a quick overview on just what the difference is in terms of benefits between the EAD and the advanced parole.
Sure, sure. So the EAD card is basically your employment authorization card. Once you do the adjustment of status, though, most of these EAD cards, if you look at it, and if it's a combo card, it'll also allow you to travel, and the travel is the advanced parole portion, which is accomplished by filing your I-131, right? So your EAD card, and sometimes because the applications are being processed separately, it's quite possible that you would still just get a regular EAD card followed by an advanced parole document which allows you to travel. But it doesn't matter. Some people prefer to have the combo card because it has both of those things on the same card. But others, essentially, like you will have an EAD card plus an advanced parole document which allows you to travel. So that's essentially the difference. For some of the student visa holders that are here, you may have limited EAD cards, but once you file for the EB-5 and you file for your adjustment of status, your EAD card will be unrestricted. You will have unrestricted employment opportunities, and also you will have the advanced parole, which allows you to travel easily without having any problems. And Sam, the advanced parole documents that we're getting now, they allow you about 4 years of travel without any issues.
Got it. Okay, perfect. And let's spend a minute and talk about the Child Status Protection Act and how does that kind of fit in with an adjustment of status filing and what the real benefit is for that.
Absolutely. So the Child Status Protection Act allows children of investors to be able to fit in the category when their parents are applying for their EB-5. So it actually is applicable to a whole bunch of different visas too, but I'll just talk about it in the context of EB-5. So basically what the Child Status Protection Act allows is it allows families to remain united. So let's say your application takes about, the whole process takes about 2 years to process, right? The CSPA will be reserved. You will reserve or freeze the child's age at the time that you actually file for your I-485. So if you're here in the United States, you file for your I-526 and then concurrently file for your I-485. Filing of the I-485 will constitute affirmative action that allows you to reserve your child's age. So once the age is frozen, it'll remain frozen until the time that everything is processed. So if the application for I-485 and the I-526, let's say it takes a year and a half to process, and let's say we file this when your child is 20 years and 6 months. So even though a year and a half passes by before the I-485 is processed, his or her age is frozen on the date that we file the I-485, which means that on the date that the I-485 is being approved and the green card is being issued, your child's age will remain under 21. So that's when we're doing the adjustment of status. Same thing happens if you're overseas, and on the date that your application I-526E is approved, your child will continue to age. So there's a little bit of disadvantage if you're filing overseas, because what happens is that you don't have the ability to file the I-485 if you're residing overseas. But what happens is that your child will continue to age as soon as your I-526 or I-526E is approved. And then the age stops again on the date that you pay for your DS-260, which is the form you file with the Department of State. So once you make that payment, which is like $445 or so, once you make that payment, then your child's age still freezes. So if for people who are like close to the 21 years mark, I would say it's much safer to adjust status here if you have that option.
All right, great. So we talked a little bit about some of the different visa categories, but let's quickly talk about them again, but in the context of, what the recommendation is in terms of trying to limit the risk when doing an adjustment of status for these.
Absolutely, absolutely. So for B1, B2, if you're here and you're thinking of possibly filing for your EB-5 and doing your adjustment of status inside the United States, for individuals who have children, it's very important for you not to take any steps that convey your intent to stay here long term. For instance, if you have a child, it's best not to register them for school. If you are here, it's best not to go and purchase a home while you're here, like on the second month that you're here. So be very careful on not taking steps that convey to U.S. immigration that you're actually here to stay long term. So that's very important for especially B1 and B2 visa holders. But once you have decided, and if your circumstances change and you decide to stay here in America, then it's very good to speak to an attorney early on to make sure that you're not taking any missteps, because sometimes, quite frankly, some people call us too late and it's difficult to walk things back. So it's a very good idea to contact an immigration lawyer early on to make sure you're not taking any missteps, especially if you're on a B1, B2 status. Now, with the F1 status, there are a lot of students who opt to file for their EB-5. If you're here for some time, there are no issues, but then the question becomes whether you should maintain your F1 status or not. I always believe in having a plan B, so I do highly recommend for individuals on F1 to also try to maintain their F1 if at all possible. So it also depends on your I-20 expiration date. So if you're here on an F1 and your I-20 expires, let's say in 2 years or 3 years, it's really not a problem, especially if you have an F1 that has a multiple visa. So if you have a multiple F1, you should not have any problems. However, Sam, it's very important that if you're at an airport and people ask you, and they may notice that there's a immigrant petition you file for an I-526 or I-526E, it's very important to be very truthful about what's happening, because the last thing you want is to get hit with an inadmissibility grounds on committing some type of fraud or anything. So for all students, for anybody entering the U.S., everything you say at the airport is recorded. So please be very careful to be truthful about your intentions. There have been circumstances, Sam, where students are not allowed re-entry because they have the pending immigrant petition. So it is important for you to try to travel on your EAD card if you are a student visa holder. Now, if you're not planning to travel outside of United States, though, you can certainly continue maintaining your F1 status. So that's with the F1s. With the H1s and the L1s, because they are dual intent, it's not so much of an issue, but I highly recommend if you're holding a B1, B2 status, or especially with the F1 students, if you're planning to travel, consult with your immigration attorney before you make any travel plans.
All right, perfect. Let's shift gears now and just chat about some common USCIS errors that happen. So even if you do everything right, there's still a chance that the government can and has made mistakes. So what are some of these mistakes that you see, and how do you try to get ahead of preventing them, and then just dealing with them if they happen anyway?
Sure, sure. So Sam, that's a very good question. A lot of mistakes happen at the mail room. So these are individuals who are not immigration lawyers. Most of them don't even have much by way of training in immigration law, and these are people who are working on the volume of scanners. There's like hundreds of scanners in the same room, and people are just opening the mail and going through the stuff. And oftentimes they miss items, or oftentimes they make mistakes. And in my office, we've had some applications that were returned in error. And what we have to do is to go back and, point out the mistake. I remember one time, it was actually last year, we had an Indian gentleman, like it was a family. We did the concurrent filing for their I-520, for their adjustment of status along with their EB-5, and they kept returning the adjustment of status, and they just didn't understand fully that this is based on the I-526E. They actually bounced it back twice, and we had to get a senator involved to get it, to get them to understand what was happening. This was happening more when the concurrent filing just came out in 22 and 23. But they do make mistakes. Sometimes they just bounce stuff back for no apparent reason. And it's just our jobs as your legal representatives to try to correct those errors. And so USCIS is not perfect by any means.
Perfect. All right, that's really helpful.
Sure.
All right, the other main topic we want to cover are some of the recent EB-5 visa demand trends, and just get an idea of what's happening in the market, because some of that could impact how long investors will need to wait to obtain their temporary green cards.
Absolutely.
So yeah, let's first start with just kind of an overall view of what demand has looked like. And looking at this slide here, we can see that demand was quite high in 2016, 17, and 18. And then when the program lapsed, it dropped down significantly for a few years. And then when it was reauthorized again in 2022, we can see that now demand is starting to pick back up. And so, main conclusion here is that now that investors are seeing approvals under the new rules post 2022, we're starting to see much more demand for the program now that investors see that it's back, it's working, and people are getting approved, as Marjan mentioned, within 12 months, especially for the rural projects with the priority processing. Again, talking about the rural priority processing, this is a scatter plot showing the approval timelines for 5 of our rural EB-5 projects here in the top right. And this basically shows that as time has gone on, for filings, towards the second half of 2023, we can see that the processing has really become more efficient by USCIS. And even more recently, in the last 7-8 months, we can see a lot of the applications are getting approved within 10 months, which is this kind of green shaded box here at the bottom. And Marjan, I know you've been in this space for quite a while. Does it sound right, from your perspective, that a lot of the rural applications are now starting to see approvals within 12 months?
Absolutely. When I talk to my clients these days, if you opt for rural, which Sam has great rural projects with I-956F approvals, those are the best ones to get into because they do process faster. According to RIA, actually, Congress mandated for rural applicants to get processed first. They do get priority, as Sam mentioned. And the reason for that is because the Congress wanted to increase job creation in those rural areas. So rural applications absolutely are processed with priority. And you mentioned 10 months. As I said, the FOIA that has data through July of 2024 puts the average at 7 months, but 10 to 12 months is very reasonable prediction.
And as we look at just overall trends in the market and how investors are choosing between rural and urban projects, this is some of the most current data, which shows about a 56% split of the market choosing urban projects and about 40% choosing rural. But what we can see is that, over the last 12 months, there's definitely a shift toward more rural applications. And so we expect the rural number to be much closer to 50% going forward.
Yes, I agree with you, Sam. I think there is an increase in interest in rural projects, and it's quite frankly, it's a good thing because if you look at the reserve visas, there are more reserve visas for rural projects. It's 20% of the visas versus 10% for TEA, and I think with the January notation, so the State Department puts out the visa availability each month on the visa bulletin. And for the first time this month, January of 2025, there's a notation on Section E as in Edward that indicates that the visas may be running out for both rural and TA for reserved visas. So this is what prompted a lot of my own Indian and Chinese clients to ask questions, are we still able to wait before we file? And my answer to all of them, Sam, is that, look, if you know your project, if you've selected your project already, if you already have your money lined up, there's really no reason to wait. Now, we do anticipate these visas to still last for a few months to come. But what happens is that if we do hit retrogression, then you may have to wait for those visas to remain, to become available. So you may not be able to file concurrently your adjustment of status unless the visa bulletin is current. It's current for the month of January. I do anticipate it to remain current for the next few months. But if it does hit retrogression, then that means you may have to wait a little bit before you can actually file for your adjustment. And again, I think this is the best time to be filing if you have your money lined up and if you have selected your project.
And let's chat for just a minute about this new language that's appeared in the January visa bulletin. What does that mean, and how should investors, kind of consider that when considering doing an adjustment of status, today?
Absolutely. So I'm just gonna read out loud the highlighted section. It says it may become necessary to establish dates for filing a final action dates during the fiscal year. So the final action dates, if you look at the visa bulletin, if you're doing the adjustment and you're inside America and you're looking at possibly doing adjustment of status, you have to look at Section B. So there's like two separate tables on the visa bulletin. You would have to look at Section B and see if you see that for a given particular month, let's say for January or February, go down to the EB-5 section in the B section and look to see whether the visa is available. If the visas are available, then you're going to see the notation C. If it's C, that means it's current. That means it's safe for you to file for your adjustment of status. If you do see a date there, let's say, if it says, I don't know, January of 2024, let's say, that means they're processing applications from January of 2024. And even though it's not linear, it kind of gives you the signal that you're retrogressed for at least like about a year, right? So you would have to kind of like make sure that you check your visa bulletin, or it's really the responsibility of your immigration lawyer to be checking that for you and to let you know whether you can still file for your adjustment of status. As I mentioned, currently everything is good. So for the month of January is good. I expect the month of February to be fine as well. However, there's a question when those visas will run out, and once those visas run out, you no longer see the C notation or current notation. Instead, you'll see a date, and that means you can't really, if you're from India and China, you wouldn't be able to file for on that particular date until the date is current. So it gets a little bit complicated, and that's why I do recommend for people to take this notation very seriously, Sam, because this wasn't here before. It just came out for January of this year, and this is what's causing a bit of concern and a bit of a rush for people to file for EB-5. And I think what's happening right now is because I can tell you just from my own experience at my office, a lot more people are filing. And what that means is that those visas will run out this year, most likely.
Got it. And how does that kind of compare, the current situation with that warning language with what we've seen historically in the past with similar language. Can you talk a little bit about kind of how that's worked, and then what does that mean, when there is a visa bulletin which becomes not current? How long do investors still have to try to do an adjustment?
So basically, if it's not current, and historically, that's a very good question, Sam. So if you look at 2015 data, people from China, Vietnam, India, they had to wait for years before they could actually file for either adjustment of status or even consular processing. So if the visa is not current, for instance, we're looking at 2015 here. I remember there was like a wait of at least 4 or 5 years for India and Vietnam. So it depends on which country you're from. The most retrogressed country historically is China, then India, and then Vietnam had a retrogression before the RIA as well. So it depends on how many people are filing. It depends on, so retrogression basically means, like, think of it as a line. It really depends on how many people are applying before you have applied, and we have no way of really knowing that. But if you look at it historically, China gets retrogressed. I remember the first time China was retrogressed was in 2014 when the visas ran out. Like the entire 10,000 visas were utilized into 2014. So China became retrogressed first, then India, and then Vietnam. So if you're from any of those countries, it's best to file sooner than later. Now, we just came back from a conference in Newport Beach for EB-5 magazine, and some of the other lawyers are of the mind that things would retrogress for all nationalities eventually. But I think I myself am more concerned about Indian and Chinese nationals right now.
Got it. And let's go through again the mechanics for if the visa bulletin does not become current, then how, let's say that, as this slide mentions, let's say that in March there's a cutoff date for high unemployment. What does that mean for Indian investors who'd be facing a non-current visa bulletin, and how long would they have to try to get in a last minute application and still be able to adjust status?
Sure, sure. So let's say if the visas, you don't no longer see the C or current notation for high unemployment, then you should seriously consider looking at rural projects, which allow you to still file concurrently for your adjustment of status. But let's say you're keen on a high unemployment area instead of like a TA, high unemployment TA area as opposed to rural, then you have to look at what the date states. And as I said, it's really not linear. So let's say it says December 3rd of 2024 is the date on the visa bulletin. And let's say by the time that you're filing, it's March of 2025. So that tells us there's like a 4-month gap between the visa availability and the current date. Now, sometimes you'll get that current, you can probably file by like in 3 or 4 months, but sometimes the retrogression jumps like 2 3 years. So it's really very difficult to say like how long you will have to wait. If it's not current, then you should really consider other categories. But this is why we are definitely encouraging people to file before they see any of those notations. And I think that's also why it's important that for people to understand that you can file using installment program where you would file with, like, let's say $200,000, $300,000. And with that, Sam, I don't know if you want us to get into that in this session, but it's very important for you to have the remainder of the money available somewhere in the world. So let's say you have an apartment in Australia up for sale, and you only have $200,000 available. Most projects, including Sam's, they do accept installment programs where you would pay the $200,000, but then we would have to show that, look, the apartment in Australia is in fact up for sale, and here's the contract, and it's committed to this EB-5 venture. So under those circumstances, I don't see any reason why you need to wait, because USCIS does allow for you to file under those circumstances, and it does allow you to reserve your priority date So then you wouldn't have to worry about retrogression, and if you have children who are approaching 21, you also freeze their age at the same time.
All right, perfect. That's really helpful.
Sure.
To wrap up, I'll just spend a few minutes just speaking quickly about a few of our open projects, and then we'll wrap up. So, as Marjan mentioned, the rural projects, we're seeing approvals in less than a year, with some more recent FOIA data as quickly as an average of about 7 months. On the rural side, we have two different rural projects currently open. Our Rocky River Loan Project, which is a large single-family home community outside of Charlotte, North Carolina. This is one of Coulter's 14 Crestwood branded communities. Coulter's developed communities like this and many other projects over the last 25 plus years. And this is just the latest rural project that we have open with Coulter. Another rural project that we have is our Tamarack Resort project, which is in Idaho. This is an ongoing master plan ski resort project. It's America's only ski, golf, and lake resort. All the jobs have already been created. We have the 956F approval already. And it has a shorter loan term of 4 + 1 + 1 years. For those investors who are okay waiting a little bit longer for the I-526C approval, particularly non-Chinese and non-Indian investors, we have our Boynton Beach Equity project, which is located in South Florida, which has a 5% annual preferred return. It's an under construction active adult apartment community. Construction's already underway, and it has the 956F approval as well. And then also on the loan side, our One Tampa loan, which is an under construction condominium tower with very strong pre-sales, construction underway, and is also a recipient of the 956F pre-approval as well. From time to time, we also have new projects listed on our website, so please check that out for the most current updates and construction videos for all of these projects and others that we have available. And to conclude, Marjan, could you spend a few minutes and kind of explain your focus on the Middle Eastern market and how clients from that geography work with you and your team in terms of translations and time zones and timing, and what kind of that process looks like from having an initial discussion, is EB-5 a good fit for my family? What documents do I need? And then how do I work together with you on the source of funds application process?
Absolutely. Thank you, Sam. So yes, I mean, I'm originally from Iran myself, so I speak Farsi. And with my office in Dubai, we cater to a lot of people from the Middle East. There are a lot of expats, especially in Dubai. So we have a lot of clients from Egypt, from India, from China, but particularly with Middle Eastern clients. The reason that I specialize in it again because of my language abilities, and we have other languages. Also, we have other staff that speak Arabic and other languages in the area. But the reason that the EB-5 program is critical to Middle Eastern people, especially from Iran and some of these more difficult countries, is that it does allow you a way to get here, because historically speaking, even getting a tourist visa for somebody from the Middle East is difficult. But the EB-5 program does not discriminate. It does allow all nationalities to participate. However, the source of funds is more difficult for countries such as Iran, even people from India and Vietnam. These are countries that have currency transfer restrictions. Particularly people from Iran, they are not able to transfer their funds directly. There's like no SWIFT code. Same thing that is happening in Russia, in fact. So that most often these individuals are forced to utilize money exchange companies. So our job is to make sure that the transfer of funds is done in a way that is acceptable under USCIS. And we work with you very closely to quickly identify a good source of funds, and then to put together a program where you would transfer your funds in a way that is you can document everything properly, in a way that we could present it properly to the USCIS.
Perfect. Thank you, Marjan. And
Of course.
For any investors who are watching this video, Marjan's contact details are here on the screen. Any questions about the EB-5 process, immigration questions, ability to adjust status, eligibility, please reach out to Marjan. And any questions related to any of the projects we discussed or about selecting a project, please use that QR code to schedule a time to chat with our team, and we'll be happy to chat with you and kind of give you an overview of what the different options are and walk through that.
Thank you, Sam.
Yep. Thank you very much, Marjan.
Oh, my pleasure. Thank you.